Hi guys, spousal support has been a hot topic for a long time, and there are some things that happened in the last few weeks that I thought you find helpful from what I experienced. For example, what is temporary support and when it's going to end, and what happened in one of my cases. Temporary spousal support is based on current income of both parties. And if one party is not working and another party is working and the divorce is ongoing, it's until the divorce is final, meaning when someone is in the clerk office stamps the copy, judgment copy that we submitted. So in a case, going back, if someone is working and the other party is not working, the working party pays 25% of gross income to the non-working. And then if both are working but have discrepancy in income, then we run this master calculator, which is a formula that we use, and we plug in the numbers on both sides and see what the amount is going to come out. And it's called base spousal support. And then we have Smith-Osler table. So Smith-Osler table is a bonus table. Why do we need a bonus table? Because if we knew in advance what each party is going to earn, we would put it into base support. But because bonus is given sporadically and not as certain, then whenever the bonus is given, then we look at the bonus table and see what's the percentage that the bonus receiver needs to pay to the other spouse. So that's one thing we really need to pay attention when temporary support is ongoing. I had a case where a spouse filed for temporary support while we submitted the judgment package to the court. So I took over the case where another mediator was settling everything and filed it, and they reserved spousal support in the paperwork of a marital settlement agreement. And the judge ordered temporary support, although, and it's correct because the judgment package, remember, hasn't been stamped to say, okay, now you're divorced. So it was on the desk. And in some counties, for example, Santa Clara, it can be on the desk for 6 months. In San Francisco, it's less, and in other counties. And there, it's a very, very difficult process because a lot of factors depend. For example, if both parties file a judgment package while one party is represented, if the represented party didn't have attorney sign off on it, the clerk will reject it. So there is a list of 100 things that clerks will pay attention, that we have as lawyers to pay attention as well. And sometimes it's unexpected. For example, like this one. How do we know? What if the lawyer subs in a day after the judgment package was so technically it's not represented, but by the time it gets on the table to the clerk. So anyway, you can tell it's very okay, I'm getting off topic. So the court ordered temporary support because the judgment package hasn't been stamped. So that's temporary support. Let's say the other spouse who is receiving the support is getting underpaid or is not getting the amount at all. What do we do? And there are lots of ways of enforcing spousal support. The most sort of aggressive way would be motion to file a motion for contempt. It's quasi-criminal. We have to prove beyond reasonable doubt that this other party is not paying, which is easy because you can show the bank statements. But we don't need to prove that the other party does not have ability to pay, because the court, by making an order to pay support, already established the ability to pay. So then the spouse who should pay now has the burden of proof to show why they don't have ability to pay, although the court established the ability to pay. It's a very, very tricky process, and sometimes on the first hearing, the spouse against whom motion for contempt has been filed will say, I plead guilty, not guilty, and then they get sometimes assigned a criminal attorney. It's very serious, especially for not paying child support. It could be very serious, and each count can result in imprisonment. Usually courts don't do that. They just order and put sanctions, but that's already later in the road. So the first tool of enforcement is motion for contempt. The spouse who is paying support or underpaying support for many, many years, many months, might reach agreements in between, right, with the other spouse and say, look, we might want to modify our initial agreement because the schedule changed, because income changed, lots of things might have changed, and they implemented this oral agreement by de facto payment, and they might have done it in a mediation or separately, but it has to be in writing. It has to be in writing, signed by both parties. Otherwise, the original order is in place. So if you're the payor and at some point you are unable to pay the amount that has been ordered because something changed to affect that ability, file immediately request for order to modify it. If you're the receiving party and you're not getting right away what you need, and you agree to a different amount but it's not in writing and you don't like it, then file an enforcement action. So, for example, another enforcement action is wage garnishment. Wage garnishment is when we send paperwork to the employer, and it's only if the payor, the person who pays, is an employee and receives paychecks. So then the wage garnishment is attached to the paycheck, and we cannot garnish more than 50% of the salary. So wage garnishment can be also for past due amounts, but again, because we're limited to only 50%, we cannot get all money back. Okay, so we have contempt, we have wage garnishment, and the third option is to file a request for order for enforcement, which is technically not necessary but it's a least aggressive way, and it gives the judge the opportunity to say, look, you need to pay this money that you owed X amount of months ago, plus sanctions, plus attorney's fees, plus 10% interest. So that needs to be paid. Okay, so request for order for enforcement, contempt, wage garnishment, and writ of execution. Writ of execution is usually used when there is no payment or underpayment. So writ of execution is attached to a court order, and it only works if we know for sure that if we send it to, writ of execution levies a bank account. So for example, if there is a lump sum of X amount of dollars that needs to be taken from the bank account, and we know where the bank is, and we send this writ of execution to that bank, then the bank will freeze that account and send us the check back. So again, it only works if we know the bank, if we know that there is money. Otherwise, it's a waste of time and money preparing all the paperwork, sending it to the bank. It might work, might not work. So those are the common ways of enforcing a court order. With spousal support. With child support, same way, and I strongly recommend to involve child support agency, because they have way more tools than non-agencies such as private practices of lawyers. They have quicker access to wage garnishment. I don't know exactly what tools they have, to be honest. I know that they might have even access to quicker getting the employment information. They might, if someone is not paying child support for more than $2,500, they can put a ban on exiting the country. There are lots of things that are that child agency have that I'm still learning based on experience. It would be actually a good conversation to invite child support agency and interview them how they enforce child support and what tools they have. I'm really curious, other than what I know. So in any case, I hope that was helpful. If you guys have any questions that I didn't cover in this video, just comment in the section below and I will cover it in a short follow-up video. Okay, I hope everything is good with you and see you soon. Bye.